It is the person who is alleging who must demonstrate this merit. It follows therefore, to the extent that the petitioner alleges that the Senate acted in violation of Section 6 of the Civil Procedure Act, the said provision is not applicable in impeachment proceedings, either before the fifth interested party or the Senate. Consequently, the allegation that the impeachment motion was sub judice because it was based on matters pending before the court cannot stand.
Yes.
But my lord, even assuming that the petitioner raised that issue of sub judice, it is important to note that that rule, unlike the Civil Procedure Act, where it's absolute, before the Senate it is not absolute. And my lord will rely on the case of Soko by the County Assembly of Nairobi City. Paragraphs 132 and 133 of the said judgment. The Supreme Court noted as follows. At the beginning of the hearing, the appellant raised a preliminary objection to the effect that the issues before the Senate were sub judice, as they were also subject to some 4 active court cases. There was a conservatory order, very critical, my lord. There was a conservatory order issued by the Employment and Labor Relations Court in petition number 3 of 2020.
Just a moment.
Sorry?
There was a conservatory
order. In that case, my lord.
Issued?
Issued.
Yes.
In ELRC petition number 35 of 2020, prohibiting the County Assembly and the Senate from proceeding with any motion, a matter which is pertinent before your lordship, for the removal of the appellant. The Speaker, in a reasoned ruling, directing that the objection be brought as part of the evidence to be presented during the proceedings in plenary. Specifically, in answer to the question of sub judice, the Speaker wrote that sub judice is not absolute. 2 key issues, my lord. Sub judice is not absolute, on one hand. Secondly, there was a conservatory order against any motion for impeachment of GWITA, while the court went on to uphold that ruling, because the court says, with that background, paragraph 132, 133, and 134 of the Sonko judgment. The court states, my lord, with that background, like the Court of Appeal, we cannot find fault in the manner the Speaker of the Senate treated the objection. But my lord, even assuming that there were sub judice matters, what is the effect? My lord, the decision on Kyoko versus Clark Nairobi City County is still the same decision. The Court of Appeal notes as follows. We need to point out, though, that a submission of the Senate to the effect that the hearing was sub judice on account of various pending suits on related charges suggests that Honorable Sonko was at all times familiar with the nature of the charges leveled against him. That may probably explain his ability to present a 118-page written response prior to the hearing before the Senate. To the contrary, Lord,
yes.
You know, or with respect to the petition and hearing, the response that she filed before the Senate was 364 pages. So she was well aware of the allegations leveled against her.
Yes.
My Lord, I wish to proceed to the next issue.
Yes.
In relation to the allegation that the impeachment of the petitioner amounts to the jeopardy, and therefore Section 33(8) of the County Governments Act violates Article 50 of the Constitution. My Lord, the nature of impeachment proceedings has been well laid out in Martin Nyagawa or the Speaker of the Senate and 6 others. My Lord, the court in that case held that impeachment proceedings are neither civil nor criminal. My lord, they are sui generis. Wambora, my lord, confirms
Yes.
that the impeachment is a judicial process.
Yes.
And the removal of a governor is not about criminality. My lord, Article 51 and Article 52 have been brought before you. And the petition alleges that her rights and Article 52 are violated. Now, it is important to distinguish these two provisions. Article 51 of the Constitution states that every person has a right to have any dispute before a court, resolved before a court, or if appropriate, another independent or impartial body of tribunal. Now, another independent and impartial tribunal body is important in this case. To control distribution, my lord, Article 52 does not start with every person, like in Article 51. Instead, it states every accused person has a right to bear charge. Now, the distinction between the use of every person and every accused person is important. Also, the distinction between another independent and impartial body or tribunal and Article 51 does not appear in Article 52. It follows, therefore, that proceedings before the Senate must follow Article 51. Article 52 and Article 52(4), which refer to acquittal and conviction, cannot apply to the petition. Crime, punishment, and sentencing, all which are included in criminal trial. The context of Article 52 cannot apply when a matter is not criminal in nature. And not because Article 50 are presented in the court of law, it follows therefore that the impeachment is not a criminal proceeding.
Just a minute. This engaged in time, obvious to have arguments before. What this engagement with counsel decision, just trying to read it up. So there's a distinction between Article 50 clause 1 and Article 50 clause 2 to Roman. Would that mean that there is no right in civil trial to be presumed to not be culpable until the content is proved? That means that is 2A. That means that we do not have a right to being upon you is elements of clause 2 would apply to some of our correspondence. For criminal matters.
Precisely.
Yes.
My lord, our jurisdiction to create authority to the effect of Article 52 does not apply to non-criminal proceedings. And that's why my lord is started by saying that Article 52 starts with an accused person. And the wording of that accused person, my lord, applies to criminal proceedings, not civil proceedings.
Okay.
And my lord, I just wish to point.
So time is back on your 5 minutes.
Thank you, my lord. I wish to point you to some of these authorities.
Yes.
There's a petition number 54 of 2014, although Duncan Orwino and 3 others by Kenyatta University.
Petition 54
of 2014, my lord.
This is High Court?
Duncan Orwino, before the High Court, my lord. And 3 others by Kenyatta University. My lord, the issue in this petition and this judgment arose from students' disciplinary hearings, where some students at Kenyatta University had been subjected to proceedings before the students' disciplinary committee.
But they were later charged with criminal case. And when they were before the court, the issue was Article 52 that subjected them to disciplinary proceedings to violate the rights to against the result. And the court said the proceedings to which the petitioners were subjected before the student disciplinary committee were quasi-judicial in nature, just like in the executive body. And they were entitled to the various rights guaranteed under Article 51 of the Constitution. However, the alleged violation of the provisions of Article 52 cannot arise in the present circumstances. My lord, another authority, the canon of 2 others of the Capital Markets Authority, it was found as follows. The wording in Article 52 leads one to draw the inference that the principle can only apply in criminal proceedings. Since acquittal or conviction only applies in criminal matters, the same cannot be said to apply in civil or administrative proceedings. But my lord, even more importantly, I wish to draw this honorable court to the last of my Ethics and the Corruption Commission. My lord, this is the decision by your brother, Justice Erasna, in which the accused person was a person who was acting as an advocate without a practicing certificate. A matter you have seen before this court proceeding. And the court found as follows. Irrespective. So this person was subjected to the disciplinary tribunal of the advocates, but then they were later charged of an offense under the Advocates Act. And they went to High Court, filed a petition alleging that their rights under Article 52 had been violated. And the court found that irrespective of whether those offenses from the petitioner's conduct, which was the subject of scrutiny by the disciplinary tribunal, in other words, would be the defense of a transverse acquit or a transverse convict be available to the petitioner or any other person, simply because he has either been acquitted or convicted by a tribunal of the nature of the disciplinary tribunal established under the Advocates Act. And the court goes into detail about the applicability of Article 52. The court says, an accused person in the sense of Article 52 of the Constitution cannot be any other person except that person who, under Section 89 of the Criminal Procedure Code, has been brought before a court of competent jurisdiction to answer to a charge formally and which contains a statement of the fair trial can only be a trial founded on or initiated by a formal charge as contemplated under Section 89 of the Criminal Procedure Code. Having said so, the petitioner may have had a dispute between him and the law society, resolved in a fair and public hearing before the disciplinary tribunal as contemplated under Article 51 of the Constitution. But that is the farthest it will go. It cannot be said by any stretch of argument that the tribunal was a court of competent jurisdiction, for it was not. Just like the tribunal. Neither can it be said that the petitioner was the accused, not the proceedings thereof, or a trial as contemplated under Article 52 of the Constitution as read in Section 89 of the Criminal Procedure Code. It follows that the petitioner was convicted by a body which is concerned with nullity, more than screening advocates. It is not a bar of subsequent prosecution of the petitioner for the offences that arose from the same set of facts that comprised the misconduct for which he was convicted of discriminatory tribunal.
Yes.
It follows therefore by law from those authorities that I just cited that Article 51 of the Constitution is not applied.
Yes.
But my Lord, I wish to point to the court that even if assuming that Article 52 applied to the petitioner, the allegations in the impeachment motion and the allegations therein were not the same. The allegation in the current impeachment motion, my Lord,
Yes.
particularly the allegation of employing a bloated workforce, was not in the previous impeachment motion. Specifically because it had further evidence which was not in the initial motion. In addition, my Lord, there was additional evidence by the report of the Auditor General and the report of the Controller of Budget at page 105, my Lord, of our bundle JK1 to JK40. My Lord, you also mentioned last week before you on the issue of sub judice that there was a deliberate misrepresentation by the petitioner on the issue that
I'll let you finish this one.
on the issue that there was an alleged murder, my Lord. The allegation, my Lord, was paying Captain Christus Manyara. It was not an allegation of murder. As pointed out in paragraph in the amended page 12 of the petitioner's amended petition. But my Lord, to conclude, what would be the effect of this court finding that Article 52 of the Constitution applies to the petition?
Yes.
My Lord, it will create a very dangerous situation because it would mean that the allegations which add a criminal element in the impeachment motion cannot be used to bring petition to be answerable to them when a matter is brought, when the same issue is brought before a criminal court. My Lord, such a finding would make sure that the petitioner is immune from criminal proceedings merely because similar matters were before the Senate or the Court Assembly in the impeachment motion. That is the very issue that Justice Jairus Miller sought to evade or avoid in Constitutional Petition number 1 of 2014. It follows therefore, my Lord, that the petition do not convince this honorable court that Article 50 by Section 33(8) of the Court of Government Act violates Article 52, rights and Article 52 of the Constitution. My Lord, unless there are any questions from the court, that's our submission.
Thank you. I don't have any questions.
Thank you, my Lord.
We've given some time to the 6th. I believe should be the 6th interested party in which other interested party in in opposition?
It's fourth, my lord.
It's fourth and
That's fourth. Yes, and sixth. 2 and medium.
third, fourth, and sixth.
Yes, my lord.
So having now had the benefit of hearing what your colleagues have submitted,
I'll try not to repeat what they have said.
keep it less than that's okay, Mr.
Thank you, my lord. I'll try to keep this request short. My lord, the third interested party
Yes.
has filed a reply on the 30th of January 2025.
Yes.
My lord, he has also filed the submissions dated April 2025. The lordship embedded of those submissions are various case laws that we also intend to rely on. My lord, we did distill about 6 issues in our submissions, and which likely the lordship mirrors the issues that were raised by the petitioners. My lord, I will try to deal with the first 3 and ask Ms. Betty to deal with the other 3. Although my lord will keep our comments short and without repeating what our colleagues have submitted. And the first issue, Your Lordship, I want to deal with is the question of whether or not the petitioner has met the threshold for you to grant the order sought in the petition. Your Lordship, I will submit from the last word that the petitioner has failed miserably. Get orders from you to quash, as it were, the proceedings and the decision of the Senate. For 3 reasons, my lord. One, on the account of not putting the proper parties before you, and my colleagues have told you enough about that. But allow me to add one more voice. My lord, a party frames their case the way they want it. The petitioner sat and filed a matter against the Senate Speaker and sought various orders, not against the Speaker, Your Lordship,
Yes.
but against Senate, as it were, and without saying so, Your Lordship, against the County Assembly, who were the initial movers of that motion. Your Lordship, when the petitioner was faced with a response by the respondent and the interested parties, in a supplementary affidavit, she wants to run away and tells you under paragraphs, I think 90 and 91, that I have no issue with the County Assembly. I have no issue with all other people. But what she's not telling the Lordship is that she has not withdrawn prayers against those parties indirectly. Your Lordship, the net effect of what the petitioner is asking you to do is try and seek orders that cannot be enforced. And my Lord, I know from where you seek that this court is not fond of making orders in vain.
Yes.
Your Lordship, the Speaker and the Senate are not synonymous. Their roles and functions, Your Lordship, cannot be substituted for each other. Your Lordship, our Constitution under Article 96 provides for the role of the Senate.
Yes.
Your Lordship, at Article 106, it provides for what is the role of the speaker and how the speaker is appointed and all matters to do with the issue of the speaker, Your Lordship. If it was the intention, Your Lordship, to have the Senate being synonymous with the speaker, then they should have shared an article in our constitution. Your Lordship,
Yes.
the petitioner and a moment to rectify this situation when they amended their petition. Your Lordship, fortunately, these matters were even conversed when we argued the issue of the conservatory order before you. We submitted very strongly, Your Lordship, about the issue of the proper parties not being before you. Instead of amending, my Lord, to even bring the proper parties before you to cure those defects as the law allows, they chose not to. My Lord, they had another opportunity
Yes.
of bringing the petition in Meru before you and seeking a consolidation. My Lord, they did not do that because of course of the mischief they wanted to perpetuate. Your Lordship, as my colleagues who are opposing the petition have said, can a party have proceedings before two concurrent high courts on the same set of facts? And when it is appropriate and convenient for them, dish out part of those proceedings, either by way of an order or a ruling, so that they can guard you from investigating or dealing with a matter that is before you. My Lord, we submit that would not be seen to be acting in good faith. It is not proper, my Lord. It bespeaks of a petitioner who has tainted hands. And my Lord, with a lot of respect, it bespeaks of a petitioner who wants to abuse the court process. Your Lordship, we do submit that by not raising, this is my second issue from the fact of not raising the threshold, by the petitioner not raising the issue of the preliminary aspect of the order before the Senate, they forfeited their right to complain about that order any other time, be it before the Senate or be it before yourself, Your Lordship. Your Lordship, this is important. And my Lord, we do take it that by their own act of not raising a preliminary point before the Senate,
Yes.
they acquiesced and consented to the jurisdiction of the Senate to deal with the matter before it. My Lord, as Mr. Ware would put it, they partook of the proceedings. They were happy with the proceedings. They consumed the proceedings, my Lord, very happy. Can they be heard, my Lord, at this juncture now to turn around and tell you you are not happy with the proceedings in the way they were conducted? There was an order from a high court in Meru stopping those proceedings. When they squandered their chance to raise that issue, my Lord, we humbly submit they cannot do that. My Lord, the case of Governor Sonko has been settled before you. And my Lord, I would want to emphasize one aspect of that case as to why Kenyans enacted the new constitution, and specifically chapter 6 of that constitution, Your Lordship.
Yes.
And I would want to say the enactment of that particular chapter was not in vain, was not cosmetic at all. My Lord, Kenyans wanted to hold the elected officers into account. My Lord, Kenyans wanted the elected officials and officers to exercise their mandates
Yes.
in a manner that they can be held accountable. My Lord, Kenyans wanted their governor or any other elected official to exercise their mandate in a manner that promotes public confidence and integrity in the office that they are elected to serve. My Lord, with a lot of humility again, Kenyans vested the responsibility on that officer to serve them and not to rule them, my Lord.
Yes.
What has happened in our matter, my Lord, is that the petitioner has opted to rule the people of Meru and not and that. Your Lordship, allow me to move to the second issue that I want to address before you, that of public interest, and which is where the third interested party comes in very strongly. Your Lordship, I wish to remind you that these proceedings go beyond the people of Meru County. My Lord, these proceedings will be precedent setting in matters and processes of impeachment. Your Lordship,
Yes.
with a lot of humility, I would want to request that these proceedings and this particular court should not be seen to overturn the will of the people of Meru,
Yes.
and which will, Your Lordship, is exercised by the Article 1 of our Constitution through the elected leaders, being the County Assembly of Meru, and who, Your Lordship, made a decision to impeach their governor. My Lord, you
Yes.
are being invited merely to review the process and not the merit of that decision that was confirmed by the Senate. My Lord,
Yes.
the impeachment process was deliberately put in our Constitution and enabling. My Lord, you're okay?
Just a moment, I've gotten a small cramp.
Sorry.
Yeah, proceed.
Thank you, Lordship. My Lord, I was submitting that the impeachment process was deliberately put in our Constitution and enabling provisions of the law. The enactors of our Constitution foresaw
Yes.
and appreciated that, with all due respect, a rogue governor could be impeached, my Lord,
Yes.
and they provided integrity and safeguards and measures to achieve this purpose.
Yes.
My Lord, the public sitting where it is expects the people with that mandate, being the members of the County Assembly, to run with that mandate, to honor the Constitution. And that is what my client as a voter in Meru has done through the elected representatives. My Lord, the will of the people will and should remain sovereign and supreme. As I submitted earlier on, the people of Meru do not want to be ruled, they want to be served.
Yes.
In your Lordship, there is necessity for you to be consistent and to be bound by decisions of the Supreme Court,
Yes.
in especially discerning that a matter of this nature befalls on public interests, and the public interest is perhaps, your Lordship,
Yes.
what has been put before you by the various parties opposing the petition. And Your Lordship, you are called upon not to minimize or look at it as a small issue. That the public who are following these proceedings, and more so the larger public of the Meru County, are at stake in these proceedings.
So that's 15 minutes. Perhaps
Yes.
with the remaining 5 or so, you could...
Sorry, Your Lordship. Yes, maybe I can address one more issue I asked related to summarize the motion of the Your Lordship, maybe if I may
Yes.
address you on one issue that I thought was pertinent. Yes, my Lord, I'm there. Is that, my Lord, I would want to kindly urge you
Yes.
not to allow, and again with a lot of respect, Your Lordship, and reservation,
Yes.
the court should not look like they are exercising what is called judicial emasculation. Emasculation. The court
Judicial
should not be seen to
emasculation.
be masculine.
I think he means judicial emasculation of other arms of government,
Thank you, Your Lordship.
where it's I'll use this time to rest my hand. It's where the judiciary is accused of taking away strength, power, and authority from other.
Indeed,
Yes.
of other constitutionally entrenched mechanisms of dealing with a rogue government. That is the point I was making. And Your Lordship, as you rest to do a judgment in this matter, we urge Your Lordship to be objective as you've always been,
Yes.
and we trust Your Lordship you will see the mischief that the petitioner has brought before you. And just one more point, my Lord, and if Parliament really wanted to, and this is more in support of the submissions made by Mr. MBERE, if it wanted to make impeachment a criminal process, then nothing would have been more than the truth than to amend the penal code and have an offense of impeachment hearing. Thank you, Lordship.
Thank you. Ms. Bouvet?
Yes.
Yes, my Lord.
Yes.
I'll try not to repeat what has been said before. I would like to start from the question as to whether the proceedings before the Senate were free and fair. The petitioner herein has alleged that the proceedings before the Senate were not free and fair. The petitioner has given 3 reasons on why she alleges that the proceedings before the Senate were not free and fair. She says the petitioner alleges that the senators were denied the right to debate and make comments on the motion of impeachment. She further alleges that the proceedings before the Senate were chaotic and disorderly. She further alleges that by denying the petitioner the right to be heard by the senators, in her closing remarks, violated her right to a fair hearing.
Yes.
My Lord, I would first start from stating that the Senate and the County Assembly are mandated to hear impeachment proceedings. That is not in doubt. My Lord, it's so surprising that the Senate and the State County Assembly are not parties to these proceedings. And I presume what the petitioner hearing wants this court to do is to determine whether indeed any of her constitutional rights, and particularly the right to a fair hearing, were infringed. The question that you then ask, my Lord, is what amounts to a fair hearing? My Lord, the Black's Law Dictionary defines a fair hearing as a judicial or administrative hearing conducted in accordance and with due process. Equity, fair play, and equal treatment are what constitutes justice. The question then that we have to ask ourselves is whether the petitioner was treated fairly, whether she was accorded a fair hearing, whether the Senate was partisan or impartial. My Lord, when the petitioner alleges that the senators were denied an opportunity to debate prior to voting of the motion to impeach her, there is no single affidavit by any senator that has been brought before this court. There is therefore no protest.
Ms. MBERE, just a moment. Let me just pause your time. The time indicates as 19 minutes 33 seconds. Just give me a moment to catch up and then also to ask a question.
Yes.
On that point of no affidavit, on Friday I asked the petitioner's counsel if they could identify the Hansard, where in a subsequent impeachment, there was a subsequent impeachment proceeding for another state officer. There was reference made to the impeachment of the petitioner. Is it filed?
Something very interesting, that answer has been pulled down from the Senate website. Completely, you can't get it. So what happened then was we made allegation in the affidavit. And
Yes.
attached now the verbatim, all of the videos that are all protesting and playing. But that answer is not the answer you can't get on the Senate website. It's completely pulled down. As much as.
Now, I was involved in the preliminaries of that other impeachment, and as things were being filed in those very many petitions that we had before they were sent to the bench, I did read it. So it is in other matters, it is very clear in my mind. Ms. MBERE, do you have an objection to anything on that point? Because I've already read it. I know the two senators who made those statements.
My Lord, at this point,
Yes.
the petitioner is duty to prove her case and not to the respondent.
But now what do I do that I already know what those said? I dealt with it in other matters. What do we do about that Hansard? Yes.
Sorry, Lord, maybe I didn't get to your point of question. I think our submissions are that there were no affidavits by the senators. And it's hearsay, so to speak.
Yes, we have some rules in our legal order about the probative value of a Hansard, and we also have rules about judicial notice. So I'll just try and paraphrase one of the senators. During that other impeachment process, that senator said something to the effect of, we should not be curtailed, limited in our debate as we were in. So I dealt with that. I read it in another matter. It was also in the public arena. What do we do? Council, it's been stated by Councillor Ngoya that this was pulled down.
First of all, Richie,
Yes.
all records of housing are contained in the website. So if council maybe had asked, tried to find out whether it is there, maybe we would have assisted him. But the allegation that it was pulled down on your lordship, without any evidence, cannot fly. Secondly, your lordship,
Yes.
and if I may respond to those issues. One, your lordship, there are no affidavits before you, as she correctly pointed out,
Yes.
testifying to those facts. Secondly, your lordship, this issue should also be considered in light of the Parliamentary Powers and Privileges Act with regard to debate and using those the debate, in essence, privileged information, if I may use that word, for purposes of proceedings, your lordship.
The challenge is it's referred to in the petitioner's affidavits, but we don't have that material.
Yes, before you just conclude.
Yes.
And thirdly, Your Lordship, if you look at that record properly, the senator who raised that issue was called to order.
Yes.
So it is a three-pronged reason.
No, I'm not making any finding on its probative value.
Yes.
I just want there to be some neatness in my record. So we leave it as it is, Ms. Mude. We just leave it. The Hansard is not here. We move on.
So just to point out, can you show the video of that day? Some of the videos that were show that doesn't know the series. Mr. Okene, something like Australia, documents. It's not sure how you say we have not proven documents in this session.
So I think it is during the only session that at the close of the highlighting.
We reserve this for judgment. We would then discuss what we do about video, and then I would also give directions on the limited filing of submissions, limited to the 13th of February ruling. Ms. Mude, you've said there is no affidavit. Would you like to comment on the Hansard? Your time is still off. Until you finish on the Hansard, that's when I'll put it on.
My Lord, I request affidavit, not affidavit.
Okay, so there's no affidavit. All right, so I'll put your time on. It's 19:33. I'll give you another 5 minutes just so that you neatly finish. Yes.
Thank you, my Lord. The petitioner has alleged that by virtue of the Senate not according her an opportunity to make her closing remarks, that her rights to a fair hearing was violated. Well, indeed, we saw a video here this morning that indicated the petitioner being given an opportunity to make her closing remarks, which she declined to do. My Lord, I wish to point out that in this entire petition, the petitioner has failed to show how exactly the Senate violated her right to a fair hearing. My Lord, in that regard,
Yes.
and in the absence of the evidence of the petitioner not being accorded a fair hearing before the Senate, it is my submission that she has failed to discharge her burden of proof as provided for in Section 107 of the Evidence Act. And my Lord, the question that we then ask ourselves is what happens if a party fails to prove their case as per the required legal standard. My Lord, this was answered in the case of Mohochi SM
Yes.
versus Mwaki. It is on page 10 of our written submissions, where the Honorable Court held that, I'm reading verbatim the last sentence of that decision, thus, if one does not discharge the burden of proof, then one will not succeed as far as that fact is concerned. Emphasis is added. My Lord, it is our submission that the petitioner has failed to discharge her burden of proof, and therefore the petition and the orders that she seeks should not be granted. My Lord, I moved the question of the constitutionality of Section 33(8) of the County Government Act.
Yes.
My Lord, in submitting of this claim, I would invite the court to examine closely and get to see what the legislature wished to cure when it enacted the said legal provision. My Lord, it is our submission that the legislature, when it was coming up with this section of the law, it was aware of, and it had the knowledge of what it is that is going on. It was aware of the societal problems, and it is these societal problems of poor leadership. I say so with utmost respect. It is the said social injustices that the legislature wished to cure. My Lord, then, if you would acquiesce to the request by the petitioner to declare Section 33(8) as unconstitutional, this would lead us to a very dangerous point where those in governance are never held accountable, where they're never held accountable for the things that they do while governing, and this would go to the hearts of, my Lord, this would go to the heart of the Constitution, would violate the sovereignty of the people, as they would not get the good leadership that they deserve. That's it. All I wish to say.
Thank you. So now we go to Consola Kenya, 4th IP. May I give you 10 minutes?
My Lord, I'll try to endeavor.
Yes, please.
My Lord, in support of our submissions, we filed the following documents.
Yes.
We have a replying affidavit filed on 17th January 2025. The affidavit itself is dated 14th January 2025.
Yes.
We also have a schedule of exhibits of the event date. We filed our written submissions dated 11th February 2025.
Yes.
And a list and bundle of authorities of the event date. If it may please the court, perhaps we may hand it over to Mr. Thank you, my Lord. From our submissions, my Lord, we've identified 7 issues for determination for this honorable court.
Yes.
And majority of these issues, my Lord, have been canvassed by my able and learned friends.
Yes.
My Lord, right from the off, I would wish to submit on the issue of clean hands.
Yes.
And my Lord, I'll direct the court to look at the contents of paragraph 88. Those are on the petitioner's further affidavit.
Just give me a moment to, let me stop your time. I'm just trying to find it. Paragraph 88.
Yes, my Lord, it's appearing at page 17.
Yes.
My Lord, the petitioner on oath affirms that with regard to paragraphs 40 to 60 of the 4th interested parties affidavit, I assert that they are in every way unrelated to the proceedings in the Senate and therefore relevant to the instant suit and the amended petition herein.
Yes.
My Lord, what is the court supposed to make of these affirmings?
Yes.
My Lord, from those very affirmings, this honorable court can draw a conclusion
Yes.
that there are no real issues in dispute regarding not only the fourth interested party, but also the fifth interested party and the sixth interested party. My Lord, this admission and oath, and I call it an admission,
Yes.
may also point to the fact that, my Lord, the petitioner tactfully avoided suing the fourth, the fifth, and the sixth interested party to actually mischievously hide the fact that, actually not the fact that, but my Lord, to hide the fact that all proceedings of the county assembly were conducted above board, and also the fact that the issues that have been raised regarding maintaining other suits on issues in dispute before you. My Lord,
Yes.
the same averment can also come to a conclusion, or can deduce a conclusion, that there were no issues pertaining to the introduction of the impeachment motion and the resolution of the county assembly to pass the impeachment motion. What do I mean? My Lord, an impeachment motion commences in the county assembly by way of a motion. By applying this admission, my Lord, the court can come to a conclusion that there were no issues, including the issues pertaining to the alleged conservatory order. There were no issues on matters to do with fair hearing at the county assembly, including the issues surrounding section 33, subsection 8 of the County Governments Act, and including the public participation process, because the public participation process is only undertaken at the county assembly. In fact, by the mere look of it, there is no controversy
Yes.
on the introduction of that motion. My Lord,
Yes.
I will address the issues to do with sub judice